Good afternoon, everyone. We're convening the Committee on Consumer Protection and Commerce. It is Wednesday, April 1st, 2026. Happy April Fool's Day. About 2:05 p.m. in conference room 329. Vice Chair, take it away.
Thank you. Before we get going, your reminder that we have a 2-minute time limit on testimony, just to make sure we stay on track for our agenda. This timer will light up with rainbow lights, and I'll ask you to wrap up your testimony. First up on the agenda is SB 3144 SD1 HD1 relating to the Hawaii Occupational Safety and Health Law. Repeals the requirement that the Department of Labor and Industrial Relations regulate hoisting machines and certify their operators, and the Hoisting Machine Operators Advisory Board, including its rules requiring a separate state crane operator certificate. First up is the Department of Labor and Industrial Relations. In support. Cool shirt.
Chair Matayoshi, Madam Vice Chair Grandinetti, Representative Jay Butai, Director of the Department of Labor and Industrial Relations. We stand in our testimony. Thank you for approving this administration bill. Following meeting with the operators, we mutually concluded that Hoisting Machine Operators Advisory Board is duplicative oversight. This measure also updates the whistleblower timeline investigation to align with federal standards. Thank you.
Thank you. Anyone else in person or on Zoom would like to testify on this measure?
Jade. Anyone else to testify? If not, sorry, Director, I have one question for you. I'm intending to move this out of committee upon with an effective date to try to avoid conference. It seems like a pretty straightforward bill, but would you rather have an effective date of upon approval, July 1st, 2026, or do you think it doesn't matter?
On approval is fine with us.
Okay. Or would July 1st work too, or do you just not care?
July 1st? July 1st
doesn't matter. Okay, sounds good. Thank you.
Thank you.
Okay, moving on to SB 2386 SD1 HD1 relating to employment earnings. Clarifies that the requirement to disclose hourly rates or salary ranges on job listings applies to full-time, part-time, temporary, or seasonal employment, exempts employers having fewer than 25 employees rather than 50 from the disclosure requirement. First up is the Hawaii State Commission on the Status of Women in Support.
Good afternoon, Yasmin Changi for the Commission on the Status of Women. I stand on our written testimony in support of this measure, as pay transparency is a proven tool in addressing wage gaps that disproportionately impact women, and clear wage information streamlines the recruitment process and makes it more efficient by setting clear expectations for both employers and applicants. Thank you very much for your consideration and support.
Thank you. AAUW Hawaii in support.
Good afternoon, Chair Matayoshi, Vice Chair Grandinetti, and Representative Iwamoto. Thank you for this opportunity. My name is Young Hyogoli, representing AAUW Hawaii. You have our written testimony. I just would like to emphasize that we ask that you remove the exemption for small businesses with less than 25 employees, because this pay transparency is something good for all businesses. And you may hear small businesses saying this is going to be a burden, but they really do know. All small businesses know what their budget is. So it's just a matter of posting it. And by the way, Gen Zers and millennials, unlike us boomers, know how to find this information anyway. So why not provide it and be transparent about it? And if you're going to ask me what the effective date should be, I will ask for January 1st, 27, to give businesses and organizations like Hawaii Employer Council opportunity to train businesses on how to do this. Thank you.
Thank you. NFIB in opposition.
We're not just giving out effective dates, by the way. On this,
5E? No, not present. Okay, anyone else in person or on Zoom who'd like to testify on this measure? Seeing none, just noting 13 individuals who submitted testimony in support. Members, any questions?
Yes, please, for the commission. So we heard a testimony from AAUW, and also the Civil Rights Commission, both supporting not exempting employers, small business employers. I'm sorry, I don't recall, did you also support removing that exemption?
Yeah, in my testimony, thank you for that
Yeah.
question. I am in support of that as well. I think all employers participating in this practice will be helpful.
Thank you.
Okay. Moving on to SB 2053 SD2 HD1 relating to transportation. Authorizes supporting documents used to transfer ownership of a motor vehicle to an insurance company after payment of damages from the result of a total loss insurance settlement to be signed electronically. Requires insurance companies to indemnify and hold harmless the Director of Finance for any claims resulting from the issuance of motor vehicle titles utilizing documents signed electronically without a notary. First up is the Department of Transportation in support on Zoom.
Wed Apr, Vice Chair, Drake Lely, Deputy Director of Transportation. We stand on our written testimony in support. Thank you.
Thank you. Copart Inc. in support on Zoom.
Yes, hi, I'm Mark Bender with Copart, and I ask for your support, Bill. It will really help the consumer as well as the business community get them through a tough time in their total loss settlement process. If you have any questions, let me know. Thank you.
Thank you. Anyone else in person or on Zoom wishing to testify on this measure? Seeing none, members, any questions? No? Okay. Moving on to SB 3102 SD2 HD1 relating to port pilotage. Clarifies the consulting role and responsibilities of the Department of Transportation in the Department of Commerce and Consumer Affairs development and implementation of port pilot licensure standards, requirements, and criteria. Repeals Port Allen from the list of designated pilotage waters. First up is the Department of Transportation in support on Zoom.
Chair and Vice Chair, Drake Lely again, Deputy Director of Transportation for Harbors. We note that this is a DCCA administrative bill, but we are in strong support. We think that the close collaborative and consultative relationship between DOT and DCCA is important. DCCA will regulate the licensure, as they currently do, of pilots who operate in our facilities, so this absolutely makes sense. And DOT also supports the exclusion of Port Allen from the waters requiring pilotage. We understand that this creates a conflict in an administrative way for the pilots that need to renew and get their licenses. And should there be an operation that requires pilotage, there is a process that the pilots have in place to ensure a safe maneuver and operation of the vessels. So we stand in support. Thank you very much. Available for questions.
Thank you. DCCA Port Pilot Program in support.
Hi, good afternoon, Chair, Vice Chair, members of the committee. I'm Danny Chow, Program Specialist for TCCA. The department stands in strong support of this bill, and we also support the amendments made as well. And I'm available for any questions you may have.
Thank you.
Thank you.
Anyone else in person or on Zoom would like to testify on this measure?
Vice Chair. Good afternoon, Chair, Vice Chair, and committee members. Thank you for having us. Sinclair Brown with the Hawaii Pilots Association. Harbor pilots bring the ships in and out of the state's designated harbors, and we stand on our written testimony in support of this bill, and I'm here to answer any questions or receive any comments. Thank you for your time.
Thank you. Any other testifiers? Seeing none, members, any questions?
This is for DOT, or DCCA is here too, right? Maybe you could come up too. So I know I said I wasn't giving out effective dates, but this is the only other bill that I do want to send out clean. Would you rather, does it matter effective date or July 1st, 2026, or do you guys not care?
I don't really think we have any preference. Yeah, having it
pass this, I think.
Okay, DOT, any preference?
We would love for it to go to conference with a clean date, so with that said, we don't have, I mean, we're ready to consult with DCCA today, so effective date doesn't matter much to us.
Okay, yeah, you can avoid conference if we send it over clean and the Senate just agrees to it, so, okay. I'll make a choice, thank you.
Thank you.
Okay, next measure is SB 2400 SD1 HD1 relating to transportation. Exempts persons operating wing and ground craft engaged in the transportation of passengers from the application of the Hawaii Water Carrier Act and defines wing and ground craft. First up is Hawaii Community Development Authority in support. Okay. Public Utilities Commission with comments.
Chair, Vice Chair, members of the committee, and a copy here from the Public Utilities Commission. Stand on our written testimony, offering comments in support of the intent of this measure. I'm available for any questions committee may have. Thank you.
Thank you. Hawaii Think Tank in support. Not present. Hawaii Sea Glider Initiative in support on Zoom.
Yes, aloha Chair, Vice Chair, members of the committee. I'm Michael Apr. I'm the Regional Director for North America at Regent Craft, also on the Hawaii Sea Glider Initiative as well. I appreciate the opportunity to testify today in strong support of the bill, and I stand on the written testimony in support. And I just wanted to add that this bill is vital because it recognizes that sea gliders are a unique class of vessel, and subjecting them to the same PUC regulations as heavy water carriers would essentially hurt innovation in terms of red tape. So we want to ensure that this remains affordable and a competitive service for Hawaii. Happy to answer any questions.
Thank you. Grassroots Institute of Hawaii in support. HMSA in support.
Chair Matayoshi, Vice Chair Gradnanedi, Representative Yomoto, Walden on behalf of HMSA. We stand on our written testimony in support of this measure. Thank you.
Thank you. Anyone else in person or on Zoom would like to testify on this measure? Seeing none, members, any questions?
I have a question for PUC. So exempting it from the search and designation will mean it will not come to you for rate increase. I mean, all of those issues that we hear in this committee. Is that how this works?
Let me try to apologize, Representative. Let me try to summarize what you're trying to ask us. So I think what you're essentially trying to ask us is by exempting sea gliders from PUC regulation or commission regulation, essentially we wouldn't be meddling in any, not meddling, sorry, that's a bad word. I said it, but we wouldn't be kind of in charge of reviewing any of the rates or any of the safety activities or any or need to get involved in any of the decisions relating to financing or other requirements under Water Carriers Acts and under our normal statutory language for utilities. Largely, they wouldn't need to come to us for any approval whatsoever.
Who would oversee safety regulations?
That would be the Coast Guard, because again, they are a craft, a vessel, and the Coast Guard does actually regulate all of the vessels in Hawaii still. They still do. It's just we're an extra added layer because of the Water Carrier Act basically says that we're gonna cover these vessels, the operator of the vessels, make sure they provide just and reasonable service.
Got it. Thank you.
So as far as safety standards, who would regulate these aircraft, these gliders? Is it FAA?
We believe the FAA would, based upon our understanding of what's happening in the continental US. They're already going after certificates from the FAA. It would kind of be the same as commuter aircraft and seaplanes. We don't regulate seaplanes, we don't regulate commuter aircrafts. So it would be under that kind of purview. I do want to note, and I think this was brought up on the companion bill when it died last time about what still remains. The harbor and smallboat harbors that sea gliders will operate out of would still need to abide by any DOT or DLNR regulations, including any types of assessed fees that they would have. So this would not alleviate them of that. This would alleviate them of coming to us for any of our approvals necessary and paying us a fee and putting forward annual financial report and other safety and operational requirements that we would put on them.
Chair, if I could add a rebuttal to that, if possible.
Sorry, I think he's on your side. Do you want to rebut that?
No.
I just wanted to make a correction
Okay.
to the record. So we are regulated by the U.S. Coast Guard, not the FAA. So we will be regulated by the Coast Guard domestically here in the U.S. and then internationally through classification societies and the International Maritime Organization.
Okay, that actually comforts me less because I mean I do want to make sure what safety standards do you have to adhere to?
So the safety standards are built into the process of the certification with the Coast Guard. So that's everything from concept reviews to risk workshops directly with the Coast Guard to design basis agreements, which is essentially the groundwork for how the vessel is designed, the safety characteristics associated with that vessel. It's about moving through the approval process for that DBA and then doing the construction and inspections and then getting a certificate of inspection from the Coast Guard. It's essentially the same path. Sorry.
So maintenance-wise, safety, I mean, just operational-wise, does the Coast Guard monitor that?
Yeah, so we work directly with the sector Coast Guard offices in the different regions in the United States. So, you know, we're working directly with the U.S. Coast Guard, you know, as a whole on the certification process, and then we work directly with the operators and the Coast Guards in those specific geographies or the sectors, as they call them, for their operation.
The Coast Guard will come to your maintenance hangar to make sure you folks are maintaining the planes properly.
Yeah, we work directly with the Coast Guard in terms of that and developing the safety protocols, the maintenance protocols that are associated with the sea glider operations.
Okay, thank you.
Chair, I have questions for Sea Glider.
Yeah, sure, go ahead.
Sea Glider,
I think the Regent is the company.
Okay, got it. So yeah, my questions are generally, so you wouldn't necessarily know about the Kewalo Basin Harbor, that could be a taking off point? You don't know about those details, is that, or do you?
I'm familiar with the harbor, and we have a good relationship with HCDA and OHA as well. And we understand that they plan to develop the harbor. I'm not saying specifically for sea gliders, but there are plans to make that harbor a lot better than it is now.
Okay, got it. And so when the sea glider is going from island to island, how many feet above the water surface does it glide?
Yeah, that's a great question. And so it's considered a Type A wing and ground effect vessel through the Coast Guard. So that means it always has to stay within a wingspan's length of the water. In our case, the wingspan is 65 feet. And so it'll fly in that 40 to 50 foot range above the water, always reading the wave heights below it and in front of it to determine its altitude.
Got it. So there's no chance, obviously, we have a lot of whales. We're a very popular destination. And so there's a lot of whales breaching, and so they never breach that high. Is that what we should assume, that there would be no accidental, unintentional collision?
It's very important to us in terms of we call it perception. So, there's a lot of perception on board from the surface to underwater to the altitude and wave perception. And what those are doing is, it's from sonar to radar to ultrasonic, and it's reading what's beneath the water, what's in front of us in the air, and it's also up to the operator to avoid those obstacles. But I don't necessarily see that as being an issue.
Okay, and then who would also determine, like, if the wave height on the south shore, if it is Kewalo Basin Harbor, for instance, in those areas, that the wave height is too, like, the surf is too big during the summer or something, like, who would make that call?
Yeah, so that's part of the feasibility study that we've done. There's certain operational windows in terms of what the wave heights are during different timeframes throughout the year. And what we've really found is, the wave tolerances for those specific areas allow it, an operational, in the 85% range. And then of course, there's buoys there that are monitored. And then we'll also, work with the operator to set up protocols in terms of how you read the current wave state if you're entering or departing the harbor.
Okay, thank you.
I have a quick question for the PUC actually.
Guys, if I misspoke earlier.
A lot of the concerns expressed by the testimony in opposition have to do with like environmental concerns and that removing the PUC oversight would remove a formal mechanism for communities to raise concerns. Would this kind of oversight even allow you to intervene on environmental concerns? And are there other, are they subject to other kinds of regulatory systems that address those separately?
I need some time to think about that. I apologize if I share. If you're asking us if we know of another agency that would have the type of oversight we would have over, the people that would the group of people that would run these sea gliders, I don't fully understand and appreciate the scale of the regulatory framework outside the commission. I do note that, we have rate cases, proceedings, people can intervene in those, we have public hearings, whatnot, and if we were to review any application before us, we have the ability to take public comment on all of them. So, do you wanna?
Yeah.
Okay, so.
I'll help you.
Yeah, sorry, so because I'm not an expert in terms of the non-PUC regulatory sphere.
David Uchiyama, Chair, Vice Chair, committee members. So we started this project actually in 2021, and we started with the EGA administration and went through all the different administrative, both state and county. The second phase to that was going to all of the environmental groups, Sierra Club, Nature Conservancy, Earth Justice, Surfrider Foundation. All of them were brought into the mix. We felt that we needed to get community support before we even considered bringing the sea glider here. The second phase to that was going out to the cultural community. So we went to, at that time, Council for Native Hawaiian Advancement on Hawaii, Council for, I can't remember, Kamehameha Schools. We even went to organizations like KUA, who oversees the fishing grounds and the fishing areas surrounding the island, the fish ponds. We've gone out to the different canoe organizations, both Okra as well as the Hawaii. So and then we went out to neighborhood boards, and we've been meeting with Rotary clubs and different community organizations to get them their input in the whole process.
Okay, thank you.
Did you have your question answered? Would hear community concerns?
No. That was helpful context. Anything else? Okay. Okay, moving on to SB 2835 SD1 HD1 relating to liquor. Part 1 clarifies that Class 10 special licenses may be granted for a period not to exceed 3 days per application. In counties fewer than 200,000 residents but not more than 100,000 residents, amends application requirements for Class 10 special licenses, including requirements related to electronic submission, naming, and single applications for certain adjacent parcels of land, and prohibits the conditional acceptance of applications based on certain factors. Part 2 increases the maximum percentage of fines assessed by county liquor commissions that may be used to fund public liquor-related educational or enforcement programs. First up is the Honolulu Liquor Commission in support.
Aloha Chair Matayoshi, Vice Chair Grandinetti, Representative Iwamoto. My name is Jeff Hong. I'm the Chair of the Honolulu Liquor Commission. Liquor commissions are organized like the police with the police commission separate from HPD. Beside me is Anna Hirai. She is representing the agency as its assistant administrator. Our administrator position is open and we're looking to fill it. We're in strong support of SB 2835. The Commission views its role as facilitating and supporting the responsible service of alcohol in our city, while we enforce regulations to protect public health and safety. Honolulu is the only county that currently issues for-profit Class 10 licenses. We have been issuing them for over 40 years. The 2008 cleanup of liquor statutes provided for free licenses for nonprofits. It is unclear from a strict reading of the current statute that for-profit licenses remain supported. We've been questioned on our authority to issue these licenses and request this technical cleanup. In my two-year tenure as chair, we've issued hundreds of these licenses to support our bars, hotels, weddings, and events like the Sony Open. By statute, we're only allowed to issue temporary licenses to businesses for 240 days. Unfortunately, the current average age of pending applications is 400 days. These licenses provide relief to our businesses. The alternative is for them to cease serving after 240 days. We have formed a permitted interaction group to address the delays caused by our rules and processes. We may return next year with requests for statutory assistance to streamline applications and processes like this bill before you. Mahalo for the opportunity to testify.
Thank you. Commissioners of the Honolulu Liquor Commission. Okay, sorry. No, sorry. Gotcha.
So just,
Rhiannon.
I'm Anna Hirai, Assistant Administrator at the Liquor Commission. Stand on my testimony in strong support of this measure. Happy to answer questions.
Thank you. Anyone else in person or on Zoom who'd like to testify on this measure? Seeing none, members, any questions?
Yeah, Bella for the Liquor Commission. Either of you.
We'll come up.
Yeah.
We just love appearing together.
We don't have a microphone, you guys can both speak. Your testimony was a little confusing. You referred to HB 1901 a number of times. It wasn't clear to me whether you were asking us to make an amendment similar to that done in HB 1901, or if you needed, were you requesting an amendment to this bill?
No, I was just sort of providing, I think it's mainly from my testimony, that for 3 years we were pursuing amendments to the Class 10 special, which was also included in this session. But there was a second important feature request having to do with the clarification of the for-profit specials. It was suggested that we continue the discussion and investigation with respect to the retail function of the Class 10 for another session. So we were willing to drop that particular amendment. It was just sort of context because the bill originally surfaced in the House Bill 1901. And it was like the third year running that we were making that request, and we're going to abandon that effort this session.
To just get the technical cleanup done.
Right.
That's the most important part that we see in the near future if we have trouble with the actual authority to grant special licenses to for-profits.
Okay, and that is not in the bill, to be clear, the technical cleanup.
The technical cleanup is in
Yes.
this bill, but the ability to take the liquor off premise, that was the part that we dropped.
Okay, yeah, that was the part I was quite against.
That part's out, okay.
The for-profit portion of this, was this always the purpose of these temporary licenses? I mean, it's almost like it's used as a gap filler right now to account for the long delays with the Liquor Commission. Right now, it's used as sort of like a Band-Aid fix until the liquor license itself can be transferred or established. Is that a fair assessment of?
I would say that's a fair assessment, but Mr.
Yeah,
Ryan?
I mean, originally, since we have a number of businesses in Honolulu County, I guess they won't mind if I name it, Cools and Catering, Events International, Free Spirits Mobile
You
Bartending.
guys attached the whole list to your testimony, so.
That basically are dependent on using the Class 10 special in conjunction with their event planning.
And do they continually apply for the special license over and over in anticipation of getting their permanent license?
No, there's two aspects of it. One is the event planners, and they're like, we're gonna have the Sony open, I need 2 days, okay. But then the other one is a restaurant that wants to open, and then they get onto their 240th day. We need to grant them something to keep the license, the restaurant open.
So the extended use is a relatively recent phenomenon. But over the past 40 years, there have been a number of events that are supported by the Class 10 for-profit special license. But only recently, as we've had challenges with licensing backlog, has it been thought to use the Class 10 special for that purpose. It's extraordinarily expensive to do so. $90 a day for a nonprofits, for a for-profit special, whereas the annual license fee for a permanent license can be, between $1,200 and $1,800 a year. So you wouldn't do it unless
you're desperate. And they're desperate because otherwise they have to be closed.
Right.
When do you, it just makes me uncomfortable because it seems like this license is being used for a purpose it was not originally intended for.
I would say that's correct.
But for-profit special always appears before the commission, published on the agenda. If someone truly had a problem with sort of inserting a licensed presence in their neighborhood, so to speak, they would have the opportunity to submit protests, because that's all. The nonprofits are done administratively.
I'm more wondering when the end of this issue will occur. I'm assuming that this is not the permanent fix to keep putting Band-Aids on Band-Aids.
We have been struggling, to be quite honest, to address this issue. You can see in my testimony that the graph is getting worse, not better. We have a permitted interaction group that's looking at streamlining our rules and our processes to address this backlog of licenses. And that's why I said we may come back additionally to have statutory fixes, like the ones that are in the testimony today, the bill today, to streamline the process of granting licenses.
Okay, I just want you to know I'm comfortable with this situation.
We are too.
Yeah, I think once the backlog situation is addressed, the use of the for-profit special will drop off relatively dramatically, because it is super expensive to do it open for business this way.
Okay, thank you.
All right, thank you.
Any other questions?
Thank you, sir. Can I have a question? So if there's a certain specific bar that neighbors have a problem with, and say they can actually try to, oppose their license renewal or something. Is that the way it works when the community has a complaint? So I guess my concern is that if they get this emergency Band-Aid extension, will they have time to get involved with the community members? For instance, if they did a Google alert to be notified if this particular community bar that they have tons of conflict with comes up, will it be a timely, will they still have an opportunity if it's noticed online or something?
So the typical case that we're describing here is somebody has already applied,
right,
and so they've gone through the process of getting a license. So there's some notifications there. When we do a special license for profit, it appears as a public hearing of which people can testify in opposition.
Got it. So they would just...
There's a requirement to send notice to the neighborhood board.
So it's the neighborhood board, okay. And so this is, again, Google alertable. Like, for instance, I can tell the community members, well, if it'll be announced on your website, and that's when they can do a flag situation for that particular establishment. Okay, thanks.
Any other questions?
I do.
Yep, Raphael Gon.
How long is the permit again?
Pardon?
How long is the permit?
Up to 3 days, but we've been granting like a ton of them in a not the exact proper use of original intent.
Thank you. Moving on to our final measure, SB 3248 SD2 HD1, relating to labeling requirements. Establishes labeling requirements for Okolehau products. First up is Department of Agriculture and Biosecurity in support.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Richard Cohen from Department of Agriculture and Biosecurity. I'm here to stand on our written testimony, and I'm also available to answer questions. Mahalo.
Thank you. Hawaiian Ola Brewing Corporation in support on Zoom.
Aloha Chair, Vice Chair, and members of the committee. My name is Naihalani Breland, President and co-founder of Ola Brew. I was really hoping I could be there in person, but we actually are opening our distillery today, so couldn't be there. I stand on my written testimony in strong support, and I also just wanted to add just kind of a little context that, you know, over the last 5 to 10 years, we've seen a lot of interest and growth in the spirits industry with more niche spirits like of tequila, like mezcal, sotols, raicias. And that's where we know that, you know, this industry is ready and it's ripe for innovation like Okolehau. And it's the perfect time right now that we really, really need to safeguard this place-based spirit because of all the history that we have. I'm also happy to answer any questions later if you guys would like about how Ola Brew and Ola Distillery can actually help to incubate this entire industry. So thank you so much for hearing my testimony, and I'm happy to answer any questions.
Thank you, and congratulations on your opening.
Thank you.
Next up is Brett Jacobson, individual in support on Zoom.
Aloha, Chair, Vice Chair, members of the committee. I'm actually the co-founder of Ola Brew with Naiha, so I'm also here opening up the distillery. We're doing tours and tastings today. It's really exciting. But I am in support of this, and I stand on my testimony. I'm here for any questions you have. I would like to say I have 15 years experience developing value-added goods from Hawaii-grown ingredients. Okolehau, I've been focusing the last 5 years on that exact product. So I've been very immersed in the history of it, the commercial cultivation of it, as well as the distillation of it. So if you guys have any questions in regards to any of those aspects, feel free to ask.
Thank you.
Thank you.
Jeffrey Hong, individual in support.
I stand in my testimony in support. I've actually been to their facility. It's beautiful, and the alcohol is tasty.
Thank you. Anyone else in person or on Zoom who'd like to testify on this measure? Seeing none, members, any questions?
I have one for Ola Brew. Either of you is fine. So right now the bill requires 51%, at least 51% local tea leaf root. I'm considering putting in kind of a graduated requirement over time for 75% in 2030 and then 100% in 2035. But I want to know from the industry's perspective, I understand you folks use almost all local root anyway, but not just for you, but if you know the rest of the industry too, is that a practical timeline to set for this? Or I don't want to hamstring your industry.
Naya, you want to go? You want?
You got it. You got it.
Okay. So as I mentioned, we've been commercially cultivating it for about 5 years now, and we've done recipes from 55% to 100% key over the years. And we've done below 55% too, just to figure out the viability. It's really expensive to grow the key root, really labor intensive to harvest it. And what we found is we can win a double gold medal with 55% key root spirit. Once you go to less than that, it starts to taste like a rum. And so the 51% level for us personally, and for like an industry producer, is that you still have a unique product that you taste unique as long as you keep it at like the 55% or above. Another problem that we've had is the fermentation rate. So when you use 100% key, which is what we're making and launching right now, you get less than half the production. What happens with the key is it's actually it's a starch, and we cook it and it turns into a sugar. The sugars aren't as fermentable when there's no other simple sugars that help get the yeast to kickstart. So essentially, if you go from a 95% key root spirit versus 100%, you get half the yield, which
So-
makes the $200 per bottle.
I think we might be talking about two different things. It's not the composition of, it's not the mix. Of the key root that you use, right now it requires 51% cultivated or harvested within the state. So we would just be requiring, however much key you guys use for the composition, but of that, right now, only half of the key root used to make that portion would have to be local. We were going to, over time, gradually move that up to 100%.
Yeah, I would.
Are you
Yeah, that makes sense.
Yeah,
no, that sounds great. 100% behind that.
I like that a lot.
Okay, and not just for you guys though, but for the other people in the industry, do you think they'd be okay with that too? Is that sustainable for you folks?
Yeah, I don't think anyone has the intent to grow key elsewhere and blend it in. I think the intent is to be able to use other fermentable sugars. And just for perspective too, like the key root is 20% sugar by weight. So if you do a brew that's 51% key root, it's really about 85% by weight key root to 15% like table sugar.
Okay. Okay, thank you guys.
Cool, thank you.
Any other questions? Seeing none?
Wait,
Oh, sure, go ahead.
Maybe I'm not understanding it, because one, I'm not a distiller. Is there a market that's a different demographic with 51% compared to, let's say, a 95% or 100%? Are there different type of purchasers?
Yeah, very, very much so. So what we're making right now, we actually just started selling our first bottles a couple hours ago. Our first tour, 80% of people bought the bottle. It was $200 a bottle. What we would like to do is build this into a very large industry for all the farmers throughout Hawaii, but being priced closer to $80 to $100 bottle can make that happen.
So when we're trying to change the percentage of the key, we're actually going to only have this labeling for a certain market area and not necessarily look at the whole entire market. So are we limiting ourselves by adding that policy, or am I just getting this totally off?
I think, as I mentioned with the 51%, it's the flavor profile. And as you dilute the amount of key root in the product more and more, it turns into more neutral spirit.
We're not touching that part though. So, so the part we're touching is how much of the key root is grown here or not.
Okay.
So instead of getting imported key from other places right now it's 51%.
Okay, so it's just the grown here. Okay. Because I thought okay, I got it.
They can mix it however they want.
Thank you.
I appreciate you bringing that up, though, Chair, because I do think that we definitely want to make sure that people are using key that's grown here in Hawaii, and not importing key. So, yeah.
Members, any other questions? Okay, take a short recess. All right, reconvening for decision making. First up on the agenda, we have SB 3144 SD1 HD1 relating to the Hawaii Occupational Safety and Health Law. Chair's recommendation is to effect the date, make it a clean date of July 1st, 2026. Members, any comments? Okay, Vice Chair for the vote.
Voting on SB 3144 SD1 HD1, Chair's recommendation is to pass with amendments. Chair and Vice Chair vote aye. Representative Chen.
Aye.
Representative Ilagan.
Aye.
Representative Ichiyama. Aye. Representative Iwamoto.
Aye.
Representative Kong.
Aye.
Representative Lowen.
Aye.
Representative Martin.
Aye.
Representative Tam.
Aye.
Representative Pierce.
Aye.
Chair, your recommendation is adopted.
Thank you, members. Moving on to SB 2386 SD1 HD1 relating to employment earnings. Chair's recommendation is to amend this bill to make it apply to all employers regardless of size. In the committee report, we will suggest the effective date of January 1st, 2027 in order to give the businesses time to come into compliance. I also just want to note that, yeah, it might restrict the small businesses some, but it sounds like they're trying to restrict wages as much as possible, so their benefit is on the backs of the workers, which I'm not really okay with. Members, any comments? Okay, Vice Chair for the vote.
Voting on SB 2386 SD1 HD1, Chair's recommendation is to pass with amendments. Are there any reservations? Representative Kong and Pierce.
No.
Oh, no vote? Okay. No vote for Representative Pierce. Okay. Any other reservations? Any noes? Okay, Chair, your recommendation is adopted.
Okay, moving on to SB 2053 SD2 HD1 relating to transportation. Chair's recommendation is to effect the date. We will also be amending the language regarding the declaration and affidavit to match the House version. Members, any comments? Okay, Vice Chair for the vote.
Voting on SB 2053 SD2 HD1, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Chair, your recommendation is adopted.
Moving on to SB 3102 SD2 HD1 relating to port pilotage. Chair's recommendation is to give it an effective date of July 1st, 2026. Members, any comments? Okay, Vice Chair for the vote.
Voting on SB 3102 SD2 HD1, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Chair, your recommendation is adopted.
Okay, moving on to SB 2400 SD1 HD1 relating to transportation. Chair's recommendation is to pass this one as is. Members, any comments?
Chair, I support this bill, but I'll be voting with reservations. I look forward to riding the Sea Glider. However, when Vice Chair asked about how the public can comment moving forward, if it is operational, what the process would be like, and we heard, anyway, it just feels like that question wasn't answered. I had additional thoughts and concerns, and for those reasons, I have reservations.
Members, any other comments? Vice Chair for the vote.
Voting on SB 2400 SD1 HD1, Chair's recommendation is to pass as is, noting reservations from Rep. Iwamoto. Any other reservations? Any noes? Chair, your recommendation is adopted.
Okay, moving on to SB 2835 SD1 HD1 relating to liquor. All right, Chair's recommendation on page 3, lines 4 through 7, there is an incomplete sentence there. So we're just going to complete the sentence by adding in pursuant to commission rule may be approved by the administrator. On page 3, lines 19 through 20, adding language to note that the exceptions to this prohibition, under this subsection. Page 4, line 17, we're going to add language indicating that the whole paragraph applies only to counties with populations between 100,000 and 200,000. Yeah, it's very specific. Anyway, members, any comments? Okay, Vice Chair for the vote.
Voting on SB 2835 SD1 HD1, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Recommendation adopted.
Okay, moving on to SB 3248 SD2 HD1 relating to label requirements, our favorite Okolehau bill. We're going to be, per our discussion in committee, we're going to be adding a subsection 7 to page 6 requiring that the key root used for the okolehau produced can be 51%, or needs to be 51% currently, move up to 75% by 2030 and 100% by 2035. Members, any comments? Okay, Vice Chair for the vote.
Voting on SB 3248, SD2, HD1, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Chair, your recommendation is adopted.
Okay, thank you, members. We're adjourned.